I'm attorney Aaron Cox. Today we're going to go over a brief breakdown of what it takes to file a non-payment of rent eviction in the state of Michigan. The first step we have to do is we have to notify the tenant that there's a problem. We do that through the sending of a demand for possession for non-payment of rent. That's a form. The form simply notifies the tenant who their landlord is and what monies are claimed to be owed at that time. That demand for possession gives the tenant 7 days to cure their breach. During that 7-day time period, the tenant has choices. They can either pay the amount of rent that is owed and remain in the property, or they can vacate from the property. If after the expiration of those 7 days, the tenant has done neither one of those things, hasn't paid you in full, and hasn't left your house, you then have the legal right to initiate a summons and complaint and a summary proceeding in a district court where the property is located. That summons and complaint is then served upon the defendant and notifies him, hey, you haven't paid your rent, and now I'm taking you to court to ask the court to issue a judgment to make you pay the rent or vacate from the property. Those court dates are usually scheduled sometime between 10 days and 3 weeks, depending on the jurisdiction in which you reside. It's just based on courts and how busy they are. Once you get your court date, you're going to appear at court. You're going to make sure that you have your lease with you, a complete breakdown of what amounts are owed and why they are owed. So you're going to want to break it down for rents, late fees, utility bills, and any other lease charges that the tenant might be responsible for. You're going to argue your case before a judge. That judge is then going to make a determination as to what amount of rent the tenant owes and is going to make a determination as to how long the tenant has to pay that rent. Now, by statute, Michigan permits a tenant 10 days in order to cure a default from a landlord-tenant judgment. So the judgment's going to say that the tenant owes, let's say, $1,500 plus any applicable court costs, and they're going to have 10 days from the date of the entry of the order in which to pay that judgment or vacate from the property. Again, they have the choice. They can either pay or stay, and in these types of proceedings, it is their choice, not yours. So once you start down the non-payment of rent path, the power is in their hands within the applicable timeframes to choose to either pay you the rent or not pay you the rent and vacate from your property. After the expiration of 10 days, they no longer have the choice. Now it's entirely up to you. You can either choose to continue to work with them, put them on some type of a payment arrangement, or otherwise just give them an extension of time in which to pay the rent, or you can choose to go to the final step in the process, which is the application for an order of eviction. This is the order that permits a bailiff to go to the property and physically remove any people or property that are located there. The filing is very straightforward and simple. The judges usually rubber stamp them and file them just as a matter of course. They are then served on your tenant. At that point, the tenant knows either they have to vacate from the property, make you happy, or otherwise pretty soon a bailiff is going to be knocking on the door.